Actually, can I detain you? You might as well have a seat now. Could all the panelists please come to the front so we will change the program slightly. We're going to have the Q&A happening now. And then, all things being considered, we are on course for lunch at 2. So whatever happens, never get between somebody from KZN and their lunch. So if people are speaking, please just go and help yourselves. That's how we're going to run the program now. So please, Romeo, Andre, Wendy, please join us at the front. And I trust you have been making notes. And yeah, we'll facilitate the Q&A because this is the part where you input, this is the part where you get value. And that's by posing questions, concerns, if there are any clarities you need. I trust the team around me will be having roving microphones so we can facilitate and move the discussion. Because a lot of the key points are about collaboration, streaming, regulation. Is this a pie in the sky? Because trust me, if we don't fix this now, every year and every platform going forward, this will be the same thing. Are there any questions or indications for people who would like to address? Please just indicate who you are and who you represent. So there's a hand there. And please also indicate who you'd like to pose the question to. Thank you. Where?
Thank you so much. I think for me, colleagues, there are just a number of things I picked up from all of you that we must look into. My name is Stanley Koza. I'm the youngest chairperson of Mushito. I'm the vice president of the Association of Independent Record Companies of South Africa and a member of the South African Music Industry Council. I want us to be clear on the issue of streaming services. We know they were not meant for Africa. When I worked with one of the artists that due to Bobby Act and Bahia, I cannot mention from here in Durban, we will sell 400,000 CDs. And that was a lot of money. We could buy properties, cars, support kids, send kids to institutions to acquire better education. How many streams do I need to make 50,000 rand? I'll leave it at that part. Secondly, I want us to teach the music industry honesty. A contract is a discussion between two people. It embodies what we spoke about, promised each other, and agreed upon. I'll speak about Tizozo. He will call us in Joburg and say, come to Mkabab. I'll pay you 25,000. He will send me a paper that says exactly that. I sign it, I send it back. If it is not paid in full, I do not perform. He signs his part, sends it back. It's an agreement. If I get to his gig, I'm not paid, I'm not performing. I don't owe him the deposit and the money paid. It's clear, it's in writing. With artists, we make a mistake. We seem to speak like artists are kids. Let me make this part clear. You go into a record company, you sign a contract. It is explained to you. Sizokuthatha waziwa. We'll get you a flat. We'll pay for you until you become somebody. But this is what we must recover once you've got a brand. The day you become famous, you want to move from that record company that paid 5 years of its money on you to become somebody. Then social media activists want to claim abuse. What are we teaching the industry? We need to have honest discussions about representation that represents artists and represents the investors in the music business. That's where the business is. Otherwise, you'll end up with artists who have no investors because you represent the right of artists. By the way, I'm a fully qualified artist a writer, composer, and an accredited royalty earner in the country. So it's important that when we're in forums like this, we are very clear on what we're building. I was here last year, I think, on the same date. My additional contribution to the issue of metadata is that, one, I hear that we want one single data. For audio royalties, it can be possible to have one data. For music videos, it's not possible to rely on what plays on radio, because music videos plays on television. So these things, there's a reason why they are separate. But beyond that, we also have another dilemma. We teach each and every year, let's all meet, let's all educate each other. The people that are supposed to be learning, I don't see them here. I see the executives who are representing the people that are not here. So my contribution to KUMISA will be, can we invite, and through SIFSA, through SAMIC, and all the structures that represent artists, can we find a way to get artists to come and learn about the business of music? Because otherwise we'll continue to talk amongst ourselves. The information will not get to the people. Lastly, the taxi industry does not have fair use. You can't go to a taxi and say, I don't have money, I need to go to Joburg. They can only help you if urochiwe, they took your wallet, you don't have money, on a serious occasion. They've got hearts. But you can't use their taxis for free just because you think will cause. Even in music, when you talk about copyright amendment bill, performance protection bill, really when we talk about fair use, is it not free use? Let's not abuse artists. Let's pay the relevance. But for us to get there, can we all collectively start talking truthfully about what the problem is? We must not separate investors in music and artists when we speak, because we will always speak to a wrong audience. Thank you.
Okay, sorry, can you keep those hands up? But sorry, I'll come to you just now. I think in terms of time, I thought I had half an hour, I actually have 15 minutes. So I'd like the panelists to quickly have a stab at responding to, hello, Mr. Khoza. And then we'll take the next round of questions. So please, with the people with the roving mics, take note of the people who have raised their hands. Wendy, I think you're the first on this one. And if any other panelists would like to take it, they'll feel free to do so. So please note their hands. Sorry, Mike?
There we go. You spoke about streaming. I agree with you wholeheartedly. I can't tell you how much money you will make if you get 50,000 streams. It depends entirely on where those users are coming from. It depends on, look, I mean, I can tell you that Apple pays well. So I'd prioritize Apple as an artist. YouTube and TikTok probably pay the worst. TikTok really doesn't pay well. But that's also part of the knowledge gap, right? Because nobody understands how TikTok pays. Artists will go live and say, I got 1 million views when I went live, but look how much I earned. That's not how TikTok pays. TikTok is, and I know I'm not answering your question, but I just wanted to illustrate the fact that it's education behind why you get paid like this or like that. As African artists, focus on your local fans when you play shows. Focus on an international fan base if you want to earn from streaming. And just back to TikTok. TikTok pays by creation, not by view or stream. So TikTok wants you to post content constantly, and at the stage that you're releasing an album or a single, it's driving their main point for existing is that it wants more users, it wants more eyeballs on the service. And how you get paid for achieving their goal is by incentivizing your fans to make creations using your sound. Back to your point about major labels, I wanted to touch on that as well, because you're right, for too often Major labels are the big bad wolf, and people don't look at the details of what happened. I think that you raise a very important point. A contract is explained to you whether it is by the label or whether it's via an independent legal advisor, and artists need to take their businesses seriously and remember the contract that they signed, because it's a legally binding document. And I think that sometimes there needs to be a separation of artist as the brand and artist as the business person, because the artist as the brand is the person that can go and incite fans on social media, but the artist as the business person behind the scenes needs to remain cool and calm and level-headed and somewhat emotionally separated from their music to achieve the optimal results, in my opinion.
Just a quick one from me. The issue of contract, there is the issue that even as you contract, there is a party that has more power than the other. And that's why even with employer contracts, employer-employee contracts, the employer usually is in a powerful position. That's why there's laws that create some form of regulation. And yes, you're free to contract, but the more there is what they call asymmetries, where the person who's the dependent contractor is less empowered, obviously the state plays a role to say, how do we allow you to contract but create conditions that are fair? Yes, in South Africa, the franchising industry, you franchise, you buy a KFC, you get on that franchise. That relationship, that shop that is now painted KFC, the staff is trained as KFC, they don't work for KFC, they have a subcontracting relationship with KFC, their main franchisor, the franchisee. There is a law that protects that relationship and ensures that upfront certain things are done properly. So if it can be done for the franchisors and franchisees who are not, this is not an employment relationship, it's a contracting relationship, why can't we create that strong base even for the sector? And it is possible, and we do intervene as a state in those situations, just that we haven't done on this one. Thanks.
Sure. Madeleine?
Yes, so I just wanted to also speak on the contract. I think in addition to what you've said, Bab, is that the problem also becomes, as much as the conversation is had with the artist and you've spoken at high level about what you want to achieve and what you're going to get, is that once it's reduced to that writing, it becomes so extremely difficult for the artist to understand, because the English is not basic English. It's not as communicated. So it becomes very tricky for any artist to sit there, for anyone to even say as a label to say, but we explained it to you, because explaining it verbally versus what's in the paper is completely different. When you're explaining to a person verbally, you also don't tell them the percentage and the splits. You'll probably tell them that we're going to sign you, we'll give you a sign-on fee of R500,000, and then we'll tell you we want 3 albums from, we'll even say an EP and then an LP, and then you don't even tell them about, well, there's actually going to be a retention period. This is how we're going to deal with the intellectual property. Or we're also including, et cetera, et cetera. There's so many conversations that don't happen at the high level discussion point that by the time it's reduced to writing, there's a lot of different things that the artist doesn't see or get, but all they hear is the 500,000 because that's what you need at that particular point in time. So I think even from a contracting point of view, the parties need to be honest and upfront at the beginning from the onset. And when you're having these negotiations, before you even put down what the numbers are going to be, you need to, as the executives, you need to have a conversation about structurally, how does this particular record label work? How do we deal with rights? How do we deal with masters? Do we have anything in our contracts on the reversion of masters after a certain period of time? Do we even allow you to buy back your masters after a certain period of time? So there's all these conversations that can be had that are not had because the desperation and the power dynamics lie with the label and the fact that there's a financial requirement. And then I think lastly, just from a fair use, fair dealings, etc., I think it's very important to realize that fair use is not free for all. It doesn't mean I can just take from somebody and just go create a song using someone else's music as a form of reference point. fair use, even in the US where the doctrine originated from, and as they elaborately put it, and I'll use the Nicki Minaj case with Tracy Chapman, where Tracy Chapman doesn't allow a lot of people to use her music whatsoever. There's no sample, there's nothing of Tracy Chapman. But Nicki Minaj did use a clip, and she was basically saying, this is how I'd want the song to be made, and I want to take it to Tracy Chapman for Tracy Chapman to okay it. If she hears it, she'll probably want to okay it. And using that bit of the sample in itself was the fair use. The problem then becomes when you actually go out and commercialize it and release it for commercial gain. You're not supposed to release it for commercial gain. So once you release it for commercial gain, then you're in the territories of licensing. And that's when you have to have that conversation. The same applies with fair dealings. The current doctrine that we have in South Africa is fair dealings, which for me is actually even a better one because it limits the kind of usage to news, information, education, etc., but doesn't speak to, I can't just take someone's song and then say, for the purpose of fair dealings, I'm using this. It has to be specific to those kind of areas that are academic and for information and knowledge and news purposes, so you can disseminate information. If we couldn't do that, then the newspapers wouldn't, and television shows or radio news wouldn't be able to use a song as an example when they're airing a story, because they must get a license from you every single time they want to play that, so it wouldn't be functional, and because it's not for commercial purposes.
Sure. Andre?
Okay, is it working now? Yeah. Okay, Romeo says you must turn one of the speakers our way because we can't hear the presentations from the floor. Besides that, it's not one data, it's one database or one back office is what we're really talking about. And as an example, I don't think everyone realizes that there used to be something called Saddle that died, and then Samro took over, and then took over and formed Capasso together with Norm, and they exist in the same bloody building. And then it was Samro that took over with Needle Time and formed Porsa, and Porsa became Sampra, and they exist in the same bloody building and 3 bloody databases. Why? So what is the biggest insurance company that we don't know in South Africa? Any answers? We know of First for Women. We know of Outsurance, and we know of Verseker for the Afrikaners, and we know of Budget, and then there's the Hippo, yeah? But the Hippo is not a company. The back office to most of those insurance companies is called Talisure. Talisure is owned by Doe Steyn, who has one of the biggest houses in the country, and is one of the richest men in the country, because he runs a back office for all of them. Another example is when you go to your bank and you want to check out your finances and your insurance, you sign a little form, access a database, and they can access everything about you. Why can't we do that in our sector?
Sure, quick one. I don't know if Tanda wants to take up this particular question. There was a question about why are the artists and creatives not here? I think if you can just speak to that.
Thank you. I think mine is quick. It's literally to respond to that. Okay, I've been asked to stand. Literally, the reason why you'll find that we don't have many artists here, and I want to correct this narrative for times to come. This gathering here is a gathering of industry leaders. Industry leaders who hardly speak to each other in the sense or the way that we are speaking to each other right now, from different or varying segments of the music ecosystem. Because remember, we've got Moshito, where we speak to artists. We've got the music Imbizo, where we speak to artists. When do we speak to each other? That's the question. So this platform is for us to speak to each other, and that's why we are speaking things that you'll find that at times the artists themselves are thinking, I don't understand this legislation. If we start speaking to each other in that way, I promise you, we will find ourselves, even when we do approach the artists. I know that some artists are represented here as we speak, because I'm an artist myself, but because we already have a pulse in the industry, and we do have somewhat of a voice where people get to listen, if we speak at least in a unified way, I'm pretty sure that through the Music Imbizo, through Moshito, through the Music Exchange, through Access, and through many other international music markets, we will speak from a position of power and authority where we can actually shape the industry where we are talking with one voice. So let's find each other. That's why we are here today. Thank you.
Thanks for the input. So I can take two more because
Chair,
my eye
Chair.
is keen on time.
Chair,
Yes, sir.
there is a request which was raised regarding your speakers.
Speakers,
At least if you can twist one of the speakers to face us.
I was hoping that would
because
be
we hardly
the-
hear,
the-
all
the-
they are facing that direction.
Sure, I was hoping one of the technical team can do that. I don't want to be moving people's speakers and then things drop. So technical team sound, can somebody please adjust the speakers? What was that your point, sir? Was that your point?
I can't hear you.
Okay, right, no, it's fine. It's being attended to. So I can take two more questions because we're really, really squeezed for time. There's one back there, and I think there's one in front, and we might have time for the one at the back. So if you can just limit it to one question, please. Just one question.
Good afternoon. My name is Sandile. Others know me as Sand B. There was a question about streams, calculation of streams. If you go to Google, you'll find something called streaming calculator or something like that. So there you can put your figures for any platform, and it will do the calculations for you and give you the figure of how much you are going to earn from whatever streaming service. It's free. So anyone can just use it. You don't need to download an app. And then, yeah, first I would like to also thank KUMISA for this opportunity, for this invitation. And for me, it's more about a little bit of contribution when it comes to the streams and album sales and all that. So I've been lucky over the few years that I do travel to different parts of the world because of my music, my performances. This is because the international markets, somewhere in 2015, they discovered my music somehow, and then we got it re-released on vinyl through some label in Canada. So from there, I also realized that the market is very, very open. We should not have cancelled the physical, like the hard copies when it comes to selling music, because South Africa is too way behind when it comes to that. Artists hardly make money. First, you have to be exposed to the international market so that you can start seeing some income. Fortunately, I'm one of those people whom I can say I earn money on streams, and also I don't have music, a lot of music that is on radio in South Africa, because from even back in the days when I started a service of CD printing for artists and cassettes, I always encourage them to say, look, the world is huge. You must always do your research and see what people use from each part of the world.
Sure.
So that you don't rely on something that you don't know if it's going to feed you now or in the future. Sell your CDs, sell your tapes, sell your records. So fortunately, I'm exposed to the vinyl market because I have my music that is distributed all over the world. I also go and do my physical distribution to different stores in different parts of the world whenever I'm free during my tours. I do that. And that exposes you as an artist to the market that has access to internet. Most of the homes, especially in Europe or US, they have Wi-Fi at home. They have record players, because records are actually selling. They have record stores all over. So if you don't have your music on vinyls or tape and relying just on streams, you're going to suffer. I see a lot of like famous artists who are well promoted, they have backup from big labels, when you look at their streams on Spotify, I beat them. I say I beat them. I have millions of streams, and it's because of that market. And I realized that instead of complaining and complaining and complaining that radio stations don't play the music, we don't get promotion, we don't get bookings, the world is huge. And when you get exposed to that market, you get gigs. I'm going to on tour in a couple of weeks. I already have some sold out gigs in Europe, like in Germany and France. And it's because of that market. And
Okay,
when
Sandy, can I please just pause it there? All I can say is congratulations, well done. Jovicho, next question, please.
okay, thank you, Sandy.
Hi, my name is Busiso. I'm representing Ikakas FM. I'd say South African artists, they make most of their money through gigs. That's what we know. But we don't speak much about the relationship between the artist and the events promoter. You'll find that I'm booking an artist who's in Joburg, and I'll call the artist management to query, and then they'll send me a contract to say, okay, this is what we require before you can even deposit the money. We want you to cover this, we want this hotel, transportation, this rider and whatnot, none. But it doesn't say anything about how the events promoter is protected. For instance, if the artist gets to the event but he's intoxicated and he's in no state to perform, what happens in that? Should the artist not pitch up for the event, what happens? And I think the biggest problem is that the artists themselves are not aware of what's in the contract, because the communication is between the events promoter and whoever is representing them in the companies. So how do you bridge that gap contractually so that everyone is represented fairly? Because when an events promoter decides to go to Yazin, when you send me a contract, I'm also going to send you my contract to say, this is what I require from you. I require you to take pictures. I require you to do like a media interview. Maybe, for instance, an event is sponsored by Kakasi, so Kakasi requires an interview with the artist. And I need you to, for whatever reason, if you don't make it to the event, I'll need you to like post a video on social media to apologize. Maybe we'll need a reimbursement or whatever. There's nothing that protects the promoters, yet the artists are making most of their money through gigs. So how do we bridge that gap? Thanks.
Okay.
Sure.
Okay, so in terms of that, the recommendation is always that both parties need to have their agreements and you issue agreement. The artist is also not going to give you an agreement for your event. As the promoter, you need to have your terms and conditions in place that stipulate the things you've just said right now. If you fail to do X, Y, Z, when we sign this contract, you're only getting 25%, for example, of how much is due to you. Once you've delivered number one, let's say it's posting and plugging and pushing it on social media, you'll get your additional 25%. At the end of the performance, not on condition that the event is successful, etc. Because what some event promoters do is that they'll say, if we exceed sales of X amount, or we make X amount, or we break even, or we make a profit, only then will you be paid. So that's why some artists want upfront payment, because I think from both sides of the equation, sometimes there's a lot of disingenuous contracting that people enter into. So either way, whether the event is successful or not, if that artist pitches, then you pay them at the end. If they arrive and they're inebriated to the point where they can't do anything, then you don't pay them the full amount, because that's part of a contractual, provision that you've stipulated in your contract. But you, as the event promoter, need to have your own agreement. And I know some artists do have their own booking agreements, etc. But you should always use your own as a service provider, because you know what your risks are. You know what you require of the artist. What they'll give you should be a technical and what we call a hospitality rider, but I think most artists focus on the hospitality rider and not the technical, and the two are being used interchangeably where it becomes a bit murky. Instead of saying in the technical rider, this is what we require from you, because if then in that technical rider they say they need the stage to be XYZ, the speakers must be this, if it's a DJ, they want CDJ 500, if it's this, they will tell you exactly what they need. If you fail to provide that, then you failed on your component of the agreement. But that's not what happens. You know, it's more on, I want the 5 bottles of Moet and Verve Yellow Label, and my entourage is 50, you know, etc. I've seen the riders, and in my mind, I'm like, that's not what's supposed to be. So, you know, it's more about how you structure to also protect yourself. You do the payments in tranches. After every deliverable you pay. And then the honesty also needs to come from your end, that if the artist does arrive, does pitch, does perform, does what they're supposed to do, if you've agreed that they'll be paid immediately after the event, at that point, once they jump off stage, then you must pay them. If you agree they'll be paid 3 days after the event, you pay them 3 days after the event. So those kind of things then require both parties, because then you know you both have skin in the game, you know, for lack of a better word, where you're booking them, you've paid them, you've shown commitment, and then they act on the commitment that you've shown to date.
Right, before I take the last question, I don't know if, Andre, you are listening in terms of, or have some anecdotal input, whereas Concert SA is concerned? Covered. Promoters, all right, cool. All right, last question in the back.
Microphone checker.
Yeah, yeah.
Don't get carried away. Sanbonani, my name is Uspepelo Mbele. I'm from the Music in Bizo, wearing 2 hats, the Music in Bizo and Downtown Music Hub. My question is directed, greetings to the panelists, and thank you very much for the information shared. My question is directed to Mr. Masor, right? There's Mr. Masor, what you were saying, you showed us Canada and an example of an association for artists in Canada and the plans that they, because in different parts of the world there's an act that governs, you know, the industry, and then a Canada based on okay. So my question is, do you not believe in South Africa that we have too many organizations that claim to represent the artists, right? To the point that there's not a few that actually lobby and create policies and fight for the industry as a whole, right? Based on, I can count numerous organizations. That is my question to you in order to execute that. And also I'd like to correct Utand with the music markets. The music markets like Mushito, Music Exchange, the Music Imbizo, Access, and all of those music markets, they're not centered around an artist. The music markets are centered around the value chain of the music industry. So when you get there into those spaces, we're not talking directly to the artists, but we're talking to the industry. And if you look at programs and what happens in those spaces, it's high level, it's for the artists, it's for everyone that operates within the industry. Thank you very much.
Just maybe, here's the thing. Bill of Rights in our Constitution talks about freedom of association. Now, and I always say also that this is important because there's also organizations who go around and say, if you're not a member of organizations, you can't access government support. Nothing like that. You can be a member of an association, you might not be a member, but accessing government support is a right that you have. When we text you, we don't text the association, we text you as government. So access to those services are equally open. So we have freedom of association. But how do you ensure that there's cohesion? And usually, if you take currently, the Performance Protection Act talks more to the not to SAMRO, but to the CAPASOs, wherein for you to be a collecting society, you need to provide the business plan application and everything, ensure that you have the systems, and apply to be accredited through CIPC. The Copyright Act obviously is going to amend and say all collecting societies need to go through that process. Then that way you say, okay, if you're not accredited to collect, you can't be collecting. You could do it that way. So even in other sectors is that you can have, you don't close off people having organizations because that's their freedom of association. But if they say they're doing a certain service, then they must be accredited or must meet a certain standard. So that's what we need to put in place. I mean, the example I made is that SAICA, which is for the chartered accountants, etc., they are not government, but they are actually accredited through the act from the Reserve Bank in terms of financial institutions to ensure that anyone who's a member of SAICA, and if they give you financial advice, they abide to a certain code of standard. So if we create those standards, then at least organizations are held to account. But we can't say there must be fewer, because then we'll be interfering with the freedom of association. But at least we need to be able to say, these are the standards, and they must be accredited, and they must be held to account. If they don't deliver to members and they do certain things, then they must be deregistered and not be allowed to operate. That's what we need to strengthen on. But the freedom to associate is freedom to associate. And no organization also should be saying, no, you must be our member. If you're not, you can't be a member of that. Constitution says you have a freedom of association. But we need, therefore, to say, if you're providing a service, these are the standards, and how do we regulate that? Thanks.
Sure. I think we're going to be calculated for a few more minutes in delay lunch, because apparently there are people who really have questions. So I'll ask a handful of questions before we close up the panel. So please, can you indicate by show of hands who has questions? One, two, three. Okay, cool. Please, can we start with the best gentleman there?
Thank you very much, sir. My name is Sakele Mzalazala. I wear different hats in the industry. Thank you very much, sir. I've got, I also have a book on music rights and business. I deal a lot with upcoming artists. I came to this platform. Actually, my question is going to be, I'm going to try and make it one question to all of our panelists, because I had another idea about this branch. We understand, or we've heard a lot about contracts. I've been listening to Mr. Masocha so many times and his presentations. Mr. Kotsumai as well, I've listened to you, you know, and Liru as well. I've been listening to you in so many platforms. What I was actually expecting from here, especially dealing with the panelists who are in front of us, was instead of asking the questions that we've been asking on contracts, you know, I was looking at asking about, can we have a contract that is either standard? I understand about the business between two parties, but can we have a contract when we're talking about a booking contract? When are we going to ask the legals that, is it fair to have a certain clause in the contract? Is it fair to give an artist a certain percentage? For instance, we've got RISA that had a policy that says that you cannot have a publishing contract on a recording contract, you know, so those contracts must be different. You know, you need to have two different contracts. So on contracts, can we have something that we can work on, you know, that will come from here, that we can adapt? Because you must remember, we're talking about different people. If you are talking about an artist is just a performer. If you are talking about a producer is just a director. So they've got different things that they are actually doing, you know. And then on digital, when they said that the internationals are here, they came here, they have the rate, they have, a certain amount of stream. We do not have that because we don't even have that system, of distributing that music and have a certain rate. We still have a challenge of a policy. But for us to build all that, can we maybe leave here saying that a contract, an artist percentage should not be more than this? I said, if we can get those advices on legal and then leave here saying that, okay, this is what we will be working on. We have CISFA that is here, we have SAMIC that is here, but it would be nice if we can work with them in understanding on what we want as the executive representing different creatives within the space. Thank you.
Okay, in terms of having a standard, you can have standard terms, but the commercials will always change because it differs from artist to artist. In terms of, with the definition of artist and differentiating, for the most part, when you're booking somebody and it's termed an artist, it's the performer. You don't really book the producer unless the producer is a DJ and also sings on that particular song. So you wouldn't necessarily book the producer. So when you are booking and negotiating these, you're also going to negotiate based on the value of that particular artist. Somebody who's just starting out, they're not particularly that well known. They don't necessarily have any wiggle room or leg room to negotiate anything that they want. But if you want an established artist, you're going to negotiate according to the level that that artist is at. The things that you can have that are standard could be around the performance requirements, because even from an equipment requirement, like I was saying earlier with the technical rider, it might be different from one artist to the other. Some artists prefer performing with a backtrack, others do want to still have a live band. Also depends on the venue. Whether you're performing in a club, I don't know if you're going to go to a club and expect to perform with a live band the same way you would do it if you're at an arena. So everything is determined by what exactly is the outcome and the ultimate goal of it. The essence of the booking, what is the booking for, the duration, when you require the person to be there, do they need to do sound check, the payment structure, how it will be paid, not necessarily the amount. Those are the kind of things that you can have. And I've seen booking agreements online that, people do download. Those are generally okay. The difference is that when you're downloading that as a template, you have certain nuances and wording that aren't used in South Africa that are used in the country that you're downloading it from. So if you're downloading something from the US, they might speak to torts instead of a delict, and in South Africa referred to a delict, and they might speak to the jurisdiction of the court being San Francisco instead of being South Africa. And as you know, in the States, all the states have different laws that apply differently. So you might find yourself in those kind of positions, but in terms of the content in the sense of what the booking requires and the performance, you would be able to take a lot from there and create a structure. So I think you can do that structurally, but you can't do so commercially.
And now for a non-legal opinion. Sorry, I'm just playing the fool. A couple of years ago, and I think the question you're really asking relates to fair trade. We even do fair trade coffee nowadays. There's a movement in Canada that I hooked up with a couple of years ago, which is about fair trade music, an international fair trade organization. And they've got 500,000 members across the world. And I think that really, when you talk about contracts, you talk about the contracting parties, and then that's their own moral conscience that steps in. But in order to have fair trade within a sector, to have some kind of standardized norms and standards, you need a collective, and you need to build those collectives, and they need to respect each other. So I'm just going to read a short paragraph from their website. So just Google Fair Trade Music, and I think Spare and KUMISA guys, that's something you may want to consider at your next event, because you are looking, if you're looking at self-regulation, then fair trade might be an important aspect of regularizing norms and standards. We aim to help people to make ethical choices when producing, distributing, streaming, or purchasing music. Our objective is a modern digital music economy that incentivizes creativity, increases access to new music, and is equitable to everyone in the music value chain. So please have a look at that, and then let's see if we can start to look at some moral and ethical and fair trade kind of dealing within our sector, not the copyright fair dealing concept.
From my side, quickly, look, it's possible. The Copyright Review Commission report said so. It also said at the time that DTI should audit yearly, even contracts of companies to see if there are terms that are actually patently unfair. Because there is something called unfair contracting. And as a state, we can play a role to say, but that is unfair contracting. Yes, it might be between you, but as a state, we can say, but that is unfair. And again, I go back to the franchising sector. The Consumer Protection Act, which the franchising sector falls under, requires certain things about the fairness of contract, about sharing of the information clearly, etc., etc. So the industry can do that and then take that as a sector code or agreed contracts by the industry, and possibly under BE code or even maybe, I don't know which other process they could use to accredit those, to register those, and then it becomes even more binding, because now, that having been approved as part of the sector code of the industry is enforceable, because then those members can then be sanctioned. So it's possible to do that, and it's something possible that needs to be done. But again, if we go to other subsectors, the best way is when the sector does those negotiations, and then government comes in to create the level playing field and say, okay, everyone agrees, this we then record as a standard that must be enforced. But it needs also the input from the sector. Yes, you don't want government to write it for you.
Yes. So in 2000, there was something called the MITT, the Music Industry Task Team process. It was pushed by government. It was done by government, and it worked quite well. And they produced about 37 recommendations. And of those recommendations, one of the most interesting one was about fair trade and fair dealing and contracts. And there was an opportunity for the record industry, who actually said at the time, let's look at all the recommendations, let's do a mea culpa, and then let's revisit contracts. Regrettably, government didn't follow through on the MITT, and I don't think those contracts that were actually agreed to being patently unfair were revisited. Government fell down.
This wasn't coming up. Sanbonan, igama lami uMpumi, Waka Phillips. I normally come here and I don't necessarily speak, even though I'm highly opinionated. So I'd like to thank you, Butando, to say that we do have the freedom to talk, even though our opinions may not necessarily be as popular as what others may think. I don't really have a question, more of a comment, because having sat in this room a couple of times, having read the information with regard to the music business branch and why KUMISA has created this branch, I feel us as industry have missed the memo. I feel like they keep harping on this every single time we're here. They're saying that it's for us as industry to come together, discuss issues, find resolution to issues, right? And at times I feel like we're turning into something where we're doing music one-on-one education, where, yes, at times we need that. We do need to know where is the status quo in terms of where the music industry is on certain topics, and then we need to identify the problem and we need to identify the solution. And as industry leaders, I think it's all on us in this room to be at that, having those type of conversations. Number one, I don't believe that we should be using the word contracts anymore, because as Stanley would say, You know, it's about an agreement between me and you. For me, I look at contracts as something that comes from the bank when I take a loan or buy a house or whatever. I take a contract. I can't negotiate that. It's what it is. You want our money, this is how we're going to do it, right? Our industry should be about agreements because it's something that we've agreed upon as two parties. We've identified issues, like Maneleng has said, that there are artists who may not necessarily understand the legalese that's written in these contracts. Let us come to solutions. What is the legal fraternity, not putting it all on you, Maneleng, but what is the legal fraternity seeing that there's this issue? There's also issue to access in terms of funds. Are we now is the legal fraternity saying, let's use law clinics in schools to try to educate them a little bit more in terms of, you know, the music industry and the music rights? I'm not saying that's the solution, but I feel like this is supposed to be the platform that we're supposed to be doing that at. And I really do feel like we are missing the memo of what KUMISA has provided in terms of the platform that and those are the discussions we should be having. Because at this point, I don't feel like we're going to come out of this lunch with having any resolutions that we can say next year, this is what we discussed, this is what we said we were going to come out and do, and this is how far we got with what we said we were going to achieve the following year, and let's move forward to the new year. I feel like we need to start looking at, identify what the problem is, try to look at, you know, possible solutions, pick one or two solutions that everybody is in agreement with, and let's try to move with it. You know, if we're talking about digital streaming and things like that, we know that access is a huge thing, and that's the access to the audience and the audience having access to data and all of that. What are we as an industry doing? Is there, you know, lobbying groups in terms of what are we doing with telcos and, you know, whoever the people are who regulate how much the cost of data is and all those kind of things? Because we know that some of these problems are beyond our industry. But as the industry leaders, I think this is the platform we should be having those type of conversations at. You know, and I really feel like we're missing out on a great opportunity that KUMISA is giving us. And this is what, you know, we really need to just get into the meat of the industry and the issues that we have and try to find solutions. And we can't always be constantly negative in finding the problems. When we're so busy finding the problems, where are we finding the solutions? Thank you.
Yeah, my name is Karabo. I used to work for Share. Now I'm actually working for Nana Quality Production, which is my own company. And I don't know how to speak of Mpumi, actually. You had a lot of valid points. But I just want to throw something to Jatem Tlaganisi, because the reason I'm saying this, there was a presentation that shows that creatives or entertainment industry made more money than agriculture, right? And when you listen to Romeo saying they always have a lesser budget for the same creative industry, there is a communication breakdown. Maybe that information plus your information can go hand in hand to government, and then you say, but we're making money. Why are we getting this budget? That's one. Two, creatives don't have money. People who come into this record company negotiating, they don't have money. They can't afford a lawyer. You know, they have to be communication between lawyers and creative industry on how they can work better. Because they cannot afford it. That's why they will go and sign those agreements. They cannot afford it. They don't understand the legal languages. The lawyers want the money. I mean, I don't know how many cases I dealt with, you know, with major labels where somebody, by suing back and forth, he lost 500,000 rand. Because it all goes to the lawyer. They charge for printing, they charge for telephone calls. You know, they don't have the money. Somehow they have to be the lawyers understanding the creatives and be able to present them properly. Record companies are animals, they are big elephants. They got the money. We have always been feeding them that money. They can afford. They can change the agreement tomorrow and make it more tighter. Their idea is to leash. They're putting that leash there. The leash will stay there until the lawyers come and want to work with the creatives to make this situation better. Record company are business people, they want to make money. There's no way that they will sacrifice their contract for a creative. We all know that. The last one. This streaming service issue thing, somehow we all know that if you look at Universal, look at Sony, somehow they're involved with these Spotify's and what. They co-own these systems. We know that. I mean, even now, they can actually make you not earn enough because they don't know where, they know that you don't know where to collect all the money. Neighboring rights, national type, whatever it is, they know you don't know how to collect it. So whatever you get in now, they frustrate you, you're gonna sell that catalog. Immediately after you sell it, a year later, they're making R1 million. We know that. Those are issues that we need to talk about and how we talk about it, how we fix them. Thank you.
Okay, just quickly, Maneleng and I had a chat outside about the way record companies operate and the way certain lawyers, not Maneleng, but the way certain lawyers operate. Some of the best entertainment lawyers you've got in the country are, of course, on retainer with record companies. So when you, and that goes for different parts of the sector, the big ones, they're on retainer. The good ones are often on retainer. So when you start to have a fight with them, they've got deep pockets. And what usually happens is that there's a threat of a lawsuit. And then there's a negotiation when you're busy running out of your money. And then the settlement takes place. And that's why most of the cases don't end up in court. And that's why there isn't many precedents for people to be able to refer back to. And I don't know what we're going to do about that.
Okay, can I jump in, Andre, even if I'm making this a conversation? I think another point that we're missing, what I was trying to make a point earlier, is the associations that represent the industry, that represent the artists, right? We have so many organizations that are sitting there claiming to represent artists and utterly not doing anything. I'll make an example. In Europe, there's an organization that represents independent companies. It's called Merlin, right? Merlin goes as far as pulling in what we have as a competition commission in South Africa to say that record labels cannot be the monopoly in a country, right? There's also indies, small businesses that need to operate in the space, right? A big part of the problem in South Africa is that we do not have proper lobbying on behalf of the industry. I think if we were to participate at association level, participate at month-to-month meetings that really pave the way forward in terms of how we interact as an industry, that could get us far.
There's something I've been trying to say, which speaks directly to that. And I think the reason why they also spoke to who is missing the memo, who is the industry, who is the we, who is the key. I'm just thinking of that, because I think it's not my thing to speak to, but I think there's an element here that we all tend to dance around. The time when I saw artists in KZN coming together for a cause that affected them across the board was when they launched BN2.
Okay, Mr. Chair, I need to go to the toilet and I'll call him Hlanganisi to come answer his question. But before I do that, when you do get the lobby together, please make it a sophisticated lobby. Don't make it like a shouting match. Get people to read, get people to write, get people to do the work and put in the effort, not just to ask for money and ask for funding. Let them do, and then think about what the differences are, and start to plan about the cases that set precedent and make them work. In Europe, in France in particular, the legislative system is slightly different, where the rights, or the droit d'auteur, the rights of the author is more important. And with many European collection societies, it's called a composers and authors and lyricists and publishers as well at the end. I think really you need to lobby for putting the creator first, and you need to think about how you do that.
'Cause I would like
Yeah, I think, Chair, it boils back to what we said at the beginning. But there's one thing we need to remember when we started this revolution. We started it yesterday. We really started the revolution yesterday. So we can't expect everything to be professional today. When the political prisoners were returned this country in 1990 and 91, the late Babu Steve Tshwete was there. He took a lead to transform sport. At that time in our industry, we were celebrating. Even 94 were celebrating. Prior 1994 were celebrating. We only stood up, Chair, 2010 as an industry to take our industry seriously. So that is when we started the process of building these organizations. So we're still at that stage. Hence, we can't be professional right now. And also, we need each and every individual, more especially in the value chain, to make sure each and every sector is organized. Like for instance, we are having a challenge right now because in the current formation, we don't have a strong organization which represents artists, which is similar to what the rugby players are doing. They got their own players association, which represent them within the rugby family. But such those organizations are being formed today, they are falling out the following day. So we need to go back to the drawing board and lobby and make sure our association are stronger. That's what is going to make our federation at a national level to be stronger, to be able to deal with this issue. To what Karabo has raised is quite important because it is a duty and spare, it's a duty of these organizations to protect the artist. It's a duty of these organizations to come up with the mechanism how they can engage lawyers of the industry to represent an artist, to represent smaller companies within the industry. Because you can't be in the Goliath, whoever, yenzeke pipeline only. You can't fight these big companies. So the industry must come up with a clear direction. How can we assist our artists to represent them? This boils down to questioning medical aid. If they can't do themselves, why the organized formation, they can't organize that, as Uspe was saying. We need to stand up as association and do what is right for the industry because no one else is going to solve it. It's us. Hence, we all agree as presenters to say, where government laws are lacking, there are gaps. Let us stand up and form our own self-regulatory body to close those gaps so that other things we can agree amongst ourselves to say, these are the rules and regulations we're going to follow. These are the standards we're going to follow. These are the code of conduct. How are we going to behave ourselves? Because even amongst ourselves, we're not even disciplined. That's the reason why we're failing to account. So it's amongst us. Thank you.
Okay. So I'd like to address the question about the legal fees. And it always comes up because it becomes a question of the services are too expensive, we can't afford the services, how do we go around it? Mechanisms have been created on going around it. However, it comes from, it then, it finally ends up at a, can we trust each other when we're contracting together? Because as a lawyer, I have on many occasions, agreed and said, no, it's fine, we'll reduce the fee or there's a different tariff and charging rates that we'll use for artists, creatives, and of course we judge according to the level that you are. You're a new up and coming artist, then the discussion is, we will work on such and such a way and such a rate, which is fundamentally reduced from how much we'd ordinarily charge. they would say at a stage when you're making the money or you get paid your amount without the money landing in our trust account, because we also believe in working on relationships of trust, then that particular artist that you would have negotiated with to say, once you get your 50,000 or whatever amount you're getting paid, you will then pay us that nominal amount that we would have given to you. That's a relationship of trust. At the end of the day, when that money lands, the relationship of trust, and contractually as well, is then broken. What do I then have to do? I have to then go through the legal process and collect and. So it's a two-way street, one. Two, in the US, how a lot of attorneys, entertainment lawyers do it, which is a model and a principle that I personally don't believe in, is that when you sign up a new artist who's up and coming, doesn't have anything except the music that they make, whether, if they own their publishing, even better. What they do is then they put up that publishing right as security to say, once you make your money from this, until you pay off my legal fees, I own the publishing in that music. A lot of entertainment lawyers in the US are extremely rich from owning publishing rights. I don't believe as a service provider I should be putting security like that and taking away rights of an artist, because all along what I have worked for is for the rights of the artist. I'm always on the side of the small player. The major labels have asked me to be on their books, etc., but I've always refused to do it because I understand how incestuous this relationship is and this industry is. There's only so many lawyers that deal with the work in this country. And all of them, like Andre rightfully said, the majority of them are in the pockets of the record labels. Those that aren't, I have to do other things outside of the entertainment law space and the creative space to actually sustain a business, because if I just did that, then I wouldn't have a sustainable business. And then thirdly, it's a business. And I think it's important, and that's why I hopped on the fact that creatives themselves and the artists themselves need to take it as a business. And when something is a business, you regulate it differently. Your priorities are different. You make provision for the things that you want and you need. So if you're saying, I need this contract to be reviewed by a lawyer, for me to actually show the commitment to this is what I'm willing to do as well. And there's always room for negotiation. So I think it would be unfair to expect, like myself, I've studied for a long period of time, have extensive experience, have done a lot of reading, have been at your Samros, been at all these different places, and have earned the fee that I charge. And I can't be expected at the level that I am to then say, oh, I'm just going to do this for free, because artists also do make money. But it's just a matter of the priorities and what they decide to do with that. So I can't be held hostage to the fact that artists don't have money purely because I'm a lawyer and they're artists. As a business person, I'm not a lawyer like an ENS lawyer, because I'm not making as much as they're making. But I could then say, I don't have money as a lawyer, so I must charge you guys 10,000 rand an hour so I can become an ENS lawyer. No, we all have to build a sacrifice and do the things that we have to do, because ultimately it's a business.
Madeleine, Wendy, Romeo, Foxtrot, Charlie. Thank you so much. You can be excused. Can you please give the panelists a round of applause, ladies and gentlemen?